In 1889, Copper King W.A. Clark and 74 other men wrote a state constitution to serve the needs of Montana's powerful interests, with a weak governor, a secretive legislature, and special tax deals for the powerful. After 60 years under the copper collar, Montana was declared the nearest thing to a colony of any American state. The Anaconda Mining Company even owned most Montana newspapers, the Copper Press. The corporate dominance of Montana's political affairs was unique in American history. 70 years after statehood, the Copper Press was finally sold, and thousands of World War II veterans had been educated under the GI Bill. Newly enlightened Montanans wanted out from under the copper collar, and big winds of change roared across the Treasure State. Changing Montana's constitution was the top priority. Strengthening the governorship, opening up the legislature, empowering citizens. Voices of Montana women, totally silenced in 1889, rang out loud and clear for these changes. When the Constitutional Convention began, 19 women were among the elected delegates. And when the delegates came together in convention, Democrats, Republicans, and Independents, men and women, young and old, sat alphabetically as equals, Montanans just wanting to make their state better. And so they did, producing a constitution for the ages, the last best constitution. Now, at its 50th anniversary, Evan Barrett and real history makers of the time shine a light on the creation of this remarkable Montana Constitution.
Welcome back to Last Best Constitution, our series of episodes about Montana's 1972 Constitution, what led up to that Constitution, the desire for change in Montana, the desire for modernization, and what happened at the convention itself, and the resulting Constitution, which has now been 50 years. This is the 50th anniversary of our 1972 Constitution, which is widely described as the best state constitution in the nation, and is respected as a constitutional document worldwide. These 50 years, of course, have a lot has transpired in those 50 years. A lot in the legal sector. A lot of amendments to the Constitution that came through the initiative process, which was a new process that wasn't in the old Constitution, where citizens can propose constitutional change. The legislature also proposes constitutional change. There have been a lot of amendments to the Constitution that way. A lot of them failed, but they've all made a difference. And then, of course, the meaning of the Constitution rubs up against statutes all the time and against things that happen in real life, and the courts are forced to make decisions. What does the Constitution mean in this particular case, and so on. And so in that case, that's where we're focusing today. Today we have two preeminent practitioners of law in Montana, both of whom have done a lot of constitutional law cases over the years, and I want to introduce those folks to you here. Jim Goetz. Jim has been a practicing attorney since I got out of Yale Law School in 1968. So you've been at this for a while.
Yes.
And I notice, I want to call attention to the two ties here, because we have a couple of Yaleys here. We have both from Yale Law School, Jim from 1968, and Raph Graybill, 2015 graduate. Raph is tied into the Constitution another way, which is your grandfather, Leo Graybill Jr., was the president of the Constitutional Convention. And I know he's probably watching right now and wondering how this is going to go. Raph has been a practitioner too in the Attorney General's office, and then in the Governor's office, and now in the private sector, and often takes on constitutional cases. So both of you have a lot of experience. I'm just the guy here that kind of rubs elbows with it a little bit. So we're going to really count on your expertise to help guide us through some of the important things that have been dealt with by initiative, by constitutional initiative or referendum, and also case law. But let me first ask you to introduce yourself a little bit, because people are interested in who we're talking to here. You came out of Ennis, did you? And tell me.
I was born in Miles City. As of the date of this filming, 80 years ago tomorrow.
Wow.
In Miles City, spent 4 years in Ismay and then moved to Ennis, where my father was the school superintendent. So I grew up and did my schooling in Ennis, and then Montana State undergraduate in history, graduate in '65, and then Yale Law School in '68, then came back. I taught a bit at the History, Government, Philosophy Department, later Political Science, it was called, at MSU. And I've started my practice in Bozeman, and I've done a fair number of constitutional cases. Stream access is probably the most famous, and I did the school funding cases and a number of cases I think we're going to talk about today.
Well, you know, we were almost contemporaries at Montana State, as we call it now. Back then it was Montana State College, before it became Montana State University. And it always seems weird to people today when you say Montana State University used to be Missoula.
Yeah. So you're a Bobcat fan, obviously.
I'm well, since I went to graduate school at I'm kind of for both. Does that sound like the right political thing to say?
You and Schweitzer.
Yeah, and thank you. And Raph, coming from the Graybill family, I know your great-grandfather was the Democratic National Committee man about 20 years before I was, and your dad, of course, in the Constitutional Convention. You've had a long history of practice of law. Tell us a little bit about your family background and your educational background.
Sure. So, as you mentioned, Leo, my grandfather, was at the Con-Con. His father was a state legislator and the Speaker of the House in the 1940s in Montana. We all came from the Great Falls area. I grew up in Great Falls, went to school there, went East Coast for school like Leo had done, and my dad had done as well, Turner. And after law school at Yale, where I just missed Jim by a couple of years, I came back to Montana. I worked on the Ninth Circuit Court of Appeals for Judge Thomas out of Billings.
Clerked for him?
Yep, clerked for him, and he was the chief judge of the Ninth Circuit at the time.
Wow.
That was a really great experience, and he's someone I know that Jim knows quite well, who is just really embodies a great Montana legal mind and collegiality, professionalism. Excellent mentor of mine, along with.
And by the way, when we talk about, we will talk a little bit about the authority of the Board of Regents under the Constitution. Sid was the first student regent in Montana history.
Yep.
And
yep.
Yeah.
So important figure in Montana. You ought to have Sid on here as well at some point.
Yeah.
So I practiced a little bit in the West Coast and then came back to Montana and was the governor's lawyer for about 4 years. Defended a variety of constitutional cases through that role. I was then the Democratic nominee for Attorney General in 2020 and was unsuccessful in that effort, as many Democrats were in 2020. And,
unfortunately.
Unfortunately. Jim was very kind in supporting me in that race. Yeah. And Jim actually was my very first donor in that campaign. Jim is someone that's been a friend and a mentor to me since before I even went to law school. And I remember I was at a talk for the Public Land Water Access Association, which Jim has been involved with. And after I gave the talk, Jim came up to me and said, "When you run, here is a check." And coincidentally, I'd been preparing to, and so I said, "Okay, if there's a good time to open an account, it's probably now." So Jim was the first guy there, and now I'm in private practice at the Graybill law firm. It's the same little law firm that my great-grandfather started in Belt, Montana in 1920. And the 6th Graybill there, and I do a variety of cases, a lot of which lately have been constitutional cases.
Yeah, well, that's really cool. Well,
I might add, by the way,
Pardon
he mentioned Sid Thomas. Yeah. Sid was a student of mine, although we missed by a couple of years at Montana
Well, that would have been
State.
the time he was, I remember it. Because
wonderful student,
yeah,
obviously.
Yeah. So, thank you for that, making humans of yourself, you know. But as we go through this, we'll go through a number of subjects here, and we're going to have a free-flowing discussion. I wanted to talk a little bit, because we just finished having an election, about the suffrage section of the Constitution, and some issues that had come to the fore, same-day registration and so on several times, and voter suppression issues that have come up, and again, where we end up with cases, constitutional cases. So, Raph, would you want to start with a little bit about the suffrage stuff? That I mean, what year was it? Was it 2004 when it was first for same-day registration came up?
Mm-hmm. Yeah, I think a good place to start with this too is, and I'm sure you've covered this in other parts of your series, one of the things that makes the Montana Constitution so unique and so innovative for its time is there's Article 2, which is the Declaration of Fundamental Rights. Mm-hmm. Federal Constitution is the Bill of Rights that don't really change that much over time. Much of it gets outsourced to courts to figure out, what the framers meant in the olden days mean now. Montana sat down and the 100 delegates said, we ought to write down the rights that are really important, and it's a comprehensive list, and it really makes being a Montanan mean something.
Like 37 sections.
Yeah.
I sometimes say we're the most protected citizens in the United States.
Right. So one of those rights, and the Supreme Court has, I think, appropriately said the most important right is the right of suffrage, because in a democratic republic, voting is sort of where you start and where you end in terms of political accountability. So back in the Constitutional Convention in '72, there was a big discussion about how much is the Constitution going to govern how elections happen in Montana, and how much of it's going to be done by statute, how much of it is going to be given to the legislature. One of the discussions at the time was to say maybe we should have what was called then poll booth registration. The idea you can walk up and register on the same day and vote as long as you meet all the requirements to vote. Well, at the ConCon they decided that was something that was important, but that the details of it were something that probably should go into the law rather than into the Constitution. The Constitution sets out principles, broad ideas that then get applied in law. So the Constitution says the legislature may establish a system of poll booth registration. You can go same day and register. That sat for quite a while. It was enacted, and then in 2004, the legislature came and said, let's do this. Let's have same-day registration. Let's allow more people to show up and vote, because if you're qualified to vote, you should be able to.
Sounds like a pretty good idea.
Decent idea. I mean, why should you have to make two trips out of something, basically, right? So the brief history on this is 2004 it comes in, or maybe in 2005 session, to check me on that. Works pretty well. About 60,000 people use this feature up until 2020. In 2014, there is an effort on the ballot to try to get rid of this, to try to take it away. The legislature actually referred it to the ballot, saying, let's get rid of same-day registration. We don't like who's voting on the same day. Maybe it's too many students, too many Democrats. I don't know. The voters didn't like that. The voters said, we think this is a good system. And using the initiative, the initiative power works both ways. It can create change. It can also prevent change. And the voters were pretty decisive. We don't want that change to happen. So fast forward to the 2020 election. New legislature comes in, 2021 session. And Montana's elections have worked pretty well. Very little voter fraud, a lot of integrity, a lot of trust in the system. But there's this national storm that starts brewing in 2020 about the presidential election. All of a sudden, the legislative majority in Montana gets interested in enacting all of these, what they would call election integrity bills. I would call voter suppression bills. But the point is, it makes it harder to vote. And so there's a whole series of bills that just showed up in Montana about 2 years ago. One changes what IDs you can use to vote. So you can use a concealed carry permit, but you can't use a student ID, for example. There's a bill that makes it basically impossible for new 18-year-olds to get absentee ballots, hurts the youth vote. There's a bill that makes it hard to help people collect their ballots and get them to the...
Which had a particular impact on reservations.
Disproportionate impact on reservations. And then the biggest really was the legislature, despite the people speaking in 2014 saying we want same-day registration, got rid of it. So there was a lawsuit, there was a series of lawsuits filed. I represented Montana's largest public employees union in a case, as well as a disability rights organization. The Democrats sued, the ACLU and the Native American Rights Fund sued, and a coalition of youth groups sued, challenging these various
all of which
changes.
were groups that seemed to be being suppressed.
Right. Right.
Yeah.
And I want to make it conversational, so I'll step back in a second. But the long and short of it was, the idea was, even though the legislature had the permission to set up same-day registration, for example, in the first place, because it implicates a fundamental right, the right to vote, once you've established that right, before you can chip away at it and take away the ability to register same day, you've got to have a really good reason as the legislature. In legal terms, you've got to have a compelling state interest that you're working towards, and you've got to make sure that what you're doing is the narrowest path to get there. Mm-hmm. So in this case, the legislature said, well, we're concerned about voter fraud, and same-day registration could have all these problems with voter fraud. And there was a trial in this case. It was a different case that went to trial than mine, but there was a trial, and trials are crucibles of truth, and they test propositions to see whether they're correct or not.
And that was the case before Moses, that he wrote a 199-page opinion in great detail that essentially threw all these out, and this is active law right now. I mean, there's a possibility of appeal of that.
Correct. So there was a 2-week trial. The state spent millions of dollars on outside counsel, and despite all that effort, they couldn't really show any voter fraud. The judge looked at all the evidence and said, this is a pretext. This is about reducing the right to vote. You didn't meet your burden. And he threw out all 4 laws, and that's currently on appeal at the Montana Supreme Court.
It is, okay. They're both on appeal. Well,
yep.
So again, this is an interesting case for people, our viewers, to know that when you pass a statute, then it has to pass muster as it compares to the Constitution. And well, this is ongoing, and so thanks for all the clarity on that. It was an extraordinarily interesting case to continue reading about.
And as a matter of policy, why wouldn't you want to encourage young people to vote?
Well, there's a philosophical position, right? Wouldn't you think in a democracy?
What a ridiculous approach.
It is always suspicious about when people want to restrict participation or voting or a citizen involvement, because if that was the crux of the Montana 1972 Constitution, we went from a corporate-dominated state and an old Constitution crafted to take care of the powerful interests of the time and empowered citizens. But for 50 years, we've seen people wanting to chip away on that citizen empowerment for 50 years. And I suspect it'll keep going. But
well, and one other thing I'd add on this, Montana has this interesting history of kind of being the opposite of the national trend. And I think in the national discussion about should we make voting harder or easier, there's kind of a suspicion that the last person to vote, the person who needs the fewest impediments to get there, might be a Democrat. So if you make voting easier, it's going to help Democrats. Yeah. I would have to imagine, based on my experience on same-day registration in Montana, I'm not sure that's true here. Yeah. I think here you make voting easier, the last person to vote might be a Republican. And so you've got...
well, that has to be sorted out, because in Montana, in our kind of libertarian tendencies, we don't register by party.
Right.
So we only have to guess whatever's going to happen that way. But yeah, well, it is an interesting area of law, and we'll have to keep an eye on it because it's very current, and it's based on the national picture too. It's going to stay current. Jim, one of the things when the Constitution was first passed, a couple important things happened related to our natural resources and our kind of semi-environmental type of stuff. I'm thinking about like the RIT and the coal tax and stuff like that. I wonder, you actually practiced in that area, or were involved, weren't you?
Yeah.
By the way, I would say RIT, I guess I should say Resource Indemnity Trust.
Right.
Yeah.
Well, backing up even further, one of the important innovations in the 72 Constitution was the 2 provisions regarding clean and healthful environment. Yes. And I had a case, I hate to date myself, but back sometime in the 70s, Montana Wilderness Association v. Beaver Creek Subdivision. And we invoked that provision to maintain standing to bring an environmental suit successfully under an opinion by Chief Justice as well. But on the last day, it was the year, I think, 76, when Paul Hatfield beat
right.
Wes Castles for Supreme Court Chief Justice. And Castle's, I call it his last parting fart of to the people of Montana. On the very last day, December 31st, he convinced the district judge to swing with him, and they reversed their decision. But that's
yeah.
history.
And it's been not adjudicated that much, surprisingly.
No, it hasn't. They kind of gutted that. But to the, you mentioned the Resource Indemnity Trust. In '74, the legislature, or there was a constitutional amendment to establish the Resource Indemnity Trust, which was based basically on Butte and the failure to clean up in the environmental mess.
And this was pre-Superfund.
Yeah.
So there was no other way to deal with it.
Right. And so a certain percentage of the money collected on taxes for resource extraction was put in a trust and available only on a supermajority vote of the legislature. Well, every time, and by the way, the same with the coal tax trust fund in 1976. They had a certain percentage you're supposed to keep inviolate.
3/4 in the case of even both houses for the coal tax.
And
much more arduous, I think.
So the legislature keeps enviously eyeing these funds, or kept back in the 70s and 80s, trying to raid them. And so I did both the RIT case for Butte Silver Bowl government. We lost that because the Supreme Court held, well, it's not clear enough that the proceeds are meant for mining damage only, because they were raiding at the state government for administrative
purposes,
and general budget. So we lost that, and Justice Skeff Sheehy dissented with his famous words, well, this is another case where the state gets the gold mine and Butte gets the shaft.
Yeah.
So then the coal trust, we were more successful. What happened is the legislature there was a tax on severance of coal, quite a bit of money in that trust fund. And they tried to relabel it as a coal licensing tax, not that tax, but a different tax to end run. So they would credit, if you paid the license tax, you would get a credit against the severance tax. So it would drain the severance tax, but there was no trust restriction on the license tax. And we got that.
That was a case of it walks like a duck, it quacks like a duck, it's a duck, right?
So anyway, we were successful in that, and the coal trust since has remained pretty inviolate.
And there was an effort, it has been sustained, and it does require a 3/4 vote of each house to do it. And then in I believe it was in 1992 election, that Stan Stevens, by initiative, put his Big Sky dividend up, which was to just take it out of the coal tax trust fund, put it into infrastructure. And I was deeply involved in that because we were trying to stop that. And so a group of us got together and put together a thing called the Treasure State Endowment, which took a portion, half the coal tax trust fund proceeds, put them into an internal trust for infrastructure that had to build over the years. But that was a statutory thing that happened, and it passed during the primary election of '92. Since it passed in the primary, when the governor was putting up a constitutional amendment, it had to go on the general election. By Constitution requires that. So all of a sudden it was already kind of half taken care of by the thing that we did. And then we went out and campaigned against it and actually beat it back. On the premise that, political words, I guess, that they're robbing your grandchildren's savings account, because the premise of the coal trust fund was you were investing money, collecting it to do something for the future when the resources were gone. So that's that's held up now over the years, and it's become such an important part of our finances of state government. What about this recent thing in '04, the right to fish and hunt suddenly got put in there? That was by initiative too.
Yes, and that hasn't been litigated. It establishes a theoretical right, not controversial in Montana, so I think that'll stand. And it's a good one.
That's godmotherhood apple pie, right?
Yeah. Another aspect of the environmental issue is when I did the stream access cases on the Dearborn and Beaverhead rivers in the mid-'80s, we relied in part on the water provision of the Constitution, basically to support our public trust argument, and that's also maintained. We won the right of, as you know, of stream access, the right to use streams, and that constitutional dimension is pretty supportive of the public trust doctrine.
And here's a case where you had to find found the constitutional basis for the right, which otherwise could be wiped out by a statutory provision anytime they want to.
Well, arguably, although I think the public trust doctrine sort of has a life of its own. So if the legislature comes tampering with that water provision, I think they're I would say doing something upstream.
Yeah. Well, great. Raph, you want to talk? You worked on both sides of an important issue to Montanans, which is we have a right to know provision of the Constitution, which is really our right to know about our government, what it's doing. And you've dealt with that on the citizen side, but you've also dealt with that because you were representing the government in some cases. And tell us a little bit about how that important right is kind of evolving.
Yeah, I mean, I think one of the bedrock principles of the 1972 Constitution is the ability of the public to participate in government. So that starts with the right to suffrage we talked about. You see it throughout. I mean, there's rules about how the legislature can enact bills, for example. You've got to have one vote on one subject. That's a pro-transparency, pro-participation measure. But probably the two most innovative and two most important are what you referenced. It's the right to participate, Article 2, Section 8, and the right to know, Article 2, Section 9. These write down in the Constitution something that was beginning to be popular in the 60s and 70s, the idea of government sunshine, government transparency. And it made those constitutional rights so that the legislature couldn't just tinker with them anytime they wanted to, keep their notes private or something like that. So there's sort of two tranches we can talk about. There's the right to participate,
Right.
and that includes
Which, by the way, my understanding is that the constitutional right to participate in government activities prior to the decision being final is something that is unique in Montana's Constitution. Participation is statutory almost everywhere else. Here it's constitutional.
And so there's the right to participate, and then there's the right to know. The one I've worked on, and we sort of take for granted the right to participate. We take for granted that under the, when the state promulgates an administrative rule, you've got an opportunity to comment. When there's a school board meeting, you get to go to that meeting, and you can sue them if they close it, typically. The one I've worked more on is the right to know, which generally deals with government communications and government documents. And what's so innovative about Montana's right to know is it says basically anything the government creates in the course of doing its business is presumptively open to you and me to look at and to see, because an important part of government accountability is the ability to know what they're doing, what they're thinking. Now, the right to know says where there's an individual right of privacy that outweighs the public's right to know, you can prevent the release of information. So, for example,
Somebody's health records. In the middle of
a child and family services record. That child or that family may have privacy rights that trump our right to know. But generally speaking, if the government creates it and keeps it, you get to look at it. And in the 70s, this was a radical idea to put in the Constitution. It was important. Today, where so much more is by text message and by email, things that would have been little conversations or phone calls are memorialized in writing, it has really expanded the window for what the public gets to see about how its government and its senior officials in particular operate. And there's this constant sort of fight that you see in the cases all the time where the government doesn't want to give up its stuff and wants to be secret and wants to, not let the public in. And the people want to know. And in other states, there's all this case law that's been invented where there's executive privilege or gubernatorial privilege or deliberative process privilege. In Montana, the public has an almost unvarnished record of winning those fights because our Constitution's so clear.
It seems that I guess it's built in they're baked into the whole system, that since the target of right to know is the government is the one that's resistant. Even though it sounds so strange, but nonetheless they are. The rub right now is trying to increase the cost of giving it. If you're a citizen and you want something, well, we're going to charge you $3,000 to ferret around and give you the documents you want, and that's become a real bone of contention now legally. I think there's a few cases going on it right now.
Right, and on the outer end, so what happened in 2015, the legislature got together and said there's a real problem of people over-requesting things. And there are situations when you don't want to have that happen. You don't want to have a private hunting, guide company come to FWP and say, give us all the radio collar locations of the best, stock you have. You don't want a telemarketing firm to say, give us all the phone numbers in your possession, state of Montana. So there are some protections like that. And there was an issue with people making these massive, massive, massive requests that would really take up public time. So the legislature passed a law in 2015 saying you can charge for the actual cost of production, what it really took you to gather the records. Well, this pernicious thing has arisen, and particularly in the last year and a half, where the government, typically a political official says, well, you do have a right to see that, sure, but we're going to have a lawyer look at it. We're going to take as much time as possible, and we're going to spend, it used to be $3,000 to see those emails. And I think some of these cases are working their way through the system, but to my ear, you don't really have a right to know if it cost you $3,000 to exercise that right to know. And if the government is responsible for filling its own emails or memos with things that it has to review to take out later, they ought to front the cost for taking it out, not you. Because otherwise, every email you want to keep secret, you say, and by the way, here's a secret, so the lawyer has to go look at it later, and you jack up the price, and all of a sudden the right to know doesn't mean a whole lot.
Well, I've got a remedy for that I'll tell you about in a second, but Jim, the public meetings flow out of the right to know. And so seems to be there's a fight now about whether or not, after the Supreme Court ruled that legislative caucuses even were subject to open meeting laws, there's now a game going on of keeping somebody outside the door so you don't have a quorum in there and nobody can go, it becomes a private meeting. Have you thought about that?
Well, I'm aware of the case last year where the court kind of allowed the Republican group to meet sort of secretly and avoid the caucus, but there are always going to be games like that, and we've always got to be vigilant about it. But for some reason, some people in government like to operate in secret, and there are times when that's important, like the Supreme Court conferences. They should not be public, in my opinion, but that's the rare exception.
Yeah. Well, my solution for this money thing is that we should take some of this $1.6 billion and create a fund that agencies can draw on to pay for their time, and maybe have an ombudsman and a small staff there that have some expertise in ferreting stuff out, so that if you've got an inexperienced staff, you're not going to tie them up. You can expedite the process and have some resources to do it. If you think of among $1.6 billion, there'd be a few dollars for openness in government, might be a good idea. So I suspect there might be a bill come up in this next session on this. I don't know how it's going to do. But
I think having an independent records ombudsman or someone like that would be a good idea, because the people that have the records have all these tricks at their disposal to try to get you not to ask for them or not to get them. And there's obviously a huge built-in conflict of interest there. And if you had some independent, we've got a model for this. The Commissioner of Political Practices is someone who is independent and makes decisions that affect office holders. A similar model would make a lot of sense for records.
And there's also, all the way back to when Tom Judge was governor in 1972, with the Constitution came, but it was statutory, was the Citizens Advocate, which is an ombudsman position for access to state government. And I can tell you this, because I was working in the governor's office at the time, that office still exists as the same phone number as it had in 1972. it functions. So these things can work, and maybe we can find a way through this. Jim, you want to talk a little bit about tort reform and what that's about, and some of the efforts that have happened on that?
Yeah, back in 1986, what happened is there are a couple cases under Article 2, I think it's Section 16, full legal redress, the right to full legal redress. And we had a couple cases post PFOST and White that struck down attempts to constrict non-economic damages. And the trial lawyers, I represented them, filed suit on that. And so what happened is...
Would you take a second and just tell our viewers what tort means?
Tort means tort means a violation of a reasonable expectation, basically, like an accident case where you don't know the person who runs into you, but you have a right if the person is negligent.
And usually it ends up meaning financial damages come into play.
Damage suits, and that's why plaintiffs' trial lawyers are interested in that, and the public should be interested because it's a means of curbing defective products, for example, defective medications. And so tort reform is basically a corporate effort to constrict damages, because obviously they don't like to pay them, but the damage is an important curb on their abusive activities. Well, anyway, the solution that the corporations came up with is to delete the words "this full" from legal redress in the Constitution. So what happened is for some reason, Walter Meyer was then Secretary of State, and they screwed it up, and instead of deleting the words "this full" in the voter information pamphlet, they added the words as if the public would vote to add those words. And so we managed on CI 30 back in about, I think it was 76 or so, we got that stricken because of the defect in the public notice of that change, and also the defect in the voter information pamphlet. So this full remains in the Constitution, although the Supreme Court later in Meachville-Hillhaven sort of watered it down. So it was sort of a Pyrrhic victory.
It goes to show you that the whole process by which you present information for voters to make choices on is so very precious. It needs to be done right. And you can, we just had some instances just 2 weeks ago where Bighorn County had 10 voting places that were misnamed. It happens around, again, voter suppression issues, around an Indian reservation. Suddenly there were 5 fictitious sites. There was no voting place there, but they went out in the Secretary of State's thing. Here's where you go to vote if you're in precinct such and such. Wrong places.
Well, in that argument, by the way, it was kind of funny because my opponent argued, well, it was just two little words.
Yeah.
So I wished I had the exhibit I had for the Supreme Court. I took about 3 different constitutional provisions and deleted or added 2 little words. So we had fun with that argument.
Oh God, yeah, no kidding, no kidding. Well, that's good to say that. Raph, we've had a couple important cases that dealt with how we amend the Constitution in terms of, I think in the, may have been when Nadelson was, it was kind of a tax revolt time after Proposition 13 in California, and there were all these different provisions being put up and tried to be put into the Constitution, the stuff that restricted the ability to tax. And they kind of put up an omnibus bill with about 20 different things in it, and it got dealt with. And then we had, and by the way, then we recently had that applied to the Marsy's Law, that about you have to only vote on one thing at a time. Explain what that's about.
Well, and that goes back to what we talked about earlier on the Montana Constitution's core value of transparency and public participation. So one of the sort of the cardinal rule in amending the Constitution by initiative is if you're going to make changes to the Constitution in more than one part, more than one change, you got to give the public a chance to vote yes or no on each part. So the most recent case on this was, you mentioned Marsy's Law. Marsy's Law is this sort of a national movement
Victims'
to
rights.
Victims' rights, and it does a lot of things. It creates victims' rights advocates. It does a bunch of different stuff related to victims' rights.
Like a complex statute would do.
Like a complex statute would be. So the Montana Constitution, not weighing in on the merits of whether Marsy's Law was a good idea or a bad idea, the Montana Constitution didn't permit that. It was not a valid enactment because as a Montana voter presented with Marsy's Law, you were given the choice of all these changes or none of these changes. And our framers, and there's a sort of corollary provision in the way the legislature writes bills called the single subject rule. Our legislature said, or our framers, excuse me, said one of the bad things about the federal system is in the federal system you can do what's called log rolling. You put a bunch of stuff together so that everyone kind of hates something, everyone kind of loves something, and you jam it through, right?
The Christmas tree approach.
Exactly, right.
Yeah.
And everyone's got something they like and something they don't like. And they said, no, in Montana, if we want to really give the voters power rather than politicians power, they've got to be able to say yes or no to each distinct change. And the Montana Supreme Court has been vigilant about enforcing this rule. If you want to change our Constitution and you're going to tinker with things, they've got to really be closely related, or else you've got to have separate votes. And I've actually been hired as an attorney to kind of help people through this process. And the thing that people come in with these great ideas, they want to pass an initiative doing this, doing that. And the first thing you got to say is, you're going to have to run 2 or 3 initiatives here if you want to really do that. And that can be frustrating at times, but what it does is it gives the power to voters and takes it away from a referring legislature or a powerful interest group, something like that.
Well, Marsy's Law was a product of a very rich Californian who made it his national mission to get this, and so he spent millions of dollars on it, and he put it up, and it was an initiative, so it would not have passed the normal process, but it got in, and then once it was voted on, I think the Supreme Court said, we're not going to adjudicate on this thing while it's pending, but if it passes, we'll take a look at it. When they passed, they said, oops, you broke all the rules, and it was voided. Otherwise, it was like 10 pages of constitutional law. It was just insane.
Well, and it's the initiative process is really important because it gives people power.
Yeah.
But there are these limitations of you don't have the kind of detailed vetting you get in a legislative session. I remember I was a law clerk, I think, when Marsy's Law signature gatherers were going around. So you go to the grocery store and say, hey, do you think that victims should have more rights? Oh, yeah, sure. Sign the thing. Yeah. And then it goes on the ballot, and it's a few words, and there's a pamphlet you could look at maybe, but there really isn't a detailed public discussion. So it's hard to say the public really had a discussion or a choice about what this Californian wanted to put on our ballot. And so whether or not that was a good policy, it was a good ruling to say you got to give people a choice if you're going to change all this different stuff.
Yeah, well, again, keeping in line with the real value thing. Jim, we've seen quite a bit of under the kind of concept of separation of powers, a lot of recent attacks on the independence of the judiciary. Some proposals to elect Supreme Court justices by district, so as if they represented people, not the law. Tell us about what's happened on that.
Well, in the last 2 years, I've handled with my co-counsel, Cliff Edwards from Billings, 2 important cases. One, the legislature tried to eliminate the Judicial Nomination Commission. That commission allowed a citizens body, provided for a citizens body to provide a list of judge nominees if there's a vacancy, and then the governor could select from that list.
And that was statutory pursuant to the Constitution, but had been in practice and used for 49 years.
Yes, and the governor apparently and the lieutenant governor didn't like it. They got it changed. We filed mid-session right after it was passed, and the Supreme Court, well, what happened is Chief Justice McGrath recused himself because he apparently had talked to the governor about it, and they appointed a district judge, and then something hit the fan because the district judges had quite properly done an email poll, because they do legitimately lobby on issues important to the courts, such as court funding and such as the nominating commission. But some in the legislature really made hay because somebody leaked this list of emails, and one of the judges who was put on the to fill the vacancy had said he's opposed to the measure. Anyway, it resulted in a major attack, an unseemly attack on the Supreme Court. They were called corrupt. They tried to use their subpoena power to get at all the emails of the court, many of which are very confidential, such as judges' performances, judges' health, so on. So that got pretty ugly last year. And then the second case, which we won, was the attempt to district the Supreme Court races so that each justice would have to represent one of 7 different districts instead of being elected statewide. And there we managed. There was a case called Reichert in 2011, what struck that. The legislature tweaked that somewhat, but they knew full well, and they were advised by legislative staff that this is probably unconstitutional. But they bowled ahead with it, and so we got it stricken this 2 months ago. So the Supreme Court has basically held that at-large voting for Supreme Court justices is constitutionally required, and so we managed to head that off. But I worry about what's going to happen this next legislative session, because a lot of legislators just do not understand the role of the courts. And one of my old professors, Alexander M. Bickel, wrote this book called The Least Dangerous Branch about the courts. And by that he meant, I think he took it from the Federalist Papers, that term. But all government is dangerous. All branches, and I agree, are dangerous. It's just more dangerous not to have them. But the courts are the least dangerous because they don't have the power of the purse. They don't have any enforcement power to speak of or military power, but they stand as a bulwark for individual rights. They're sort of called counter-majoritarian to curb the abuse of the framers called it the mob, democracy out of control. So it's very important that we understand the role of the judges, and they're handicapped in their ability to respond to these public charges, because judges are supposed to be above that political fray. So I just thought it was very unfortunate and unseemly what happened in 2021, and I worry that that's about what's going to happen this next session.
Well, as our viewers are watching this series, there will be a legislature being held. And in that legislature, one party has a supermajority and can, if they stay monolithic and hold on, they can push any amendment they want into, at least out to the voters. One of the most common things you find is that you're right, they don't understand the role, and so obviously, if you do little, civics 101, and understand Marbury versus Madison and judicial review concepts, that hey, when you pass a law, it has to be pass muster with the Constitution, because the Constitution is above it. Your statutes have to meet constitutional
and the judges have to enforce and apply the Constitution. It's not always a black and white question.
Yeah.
That's why they're called judges. They use their good judgment.
And by the dozens, legislators will be told by the staff attorneys I want a bill to do such and such, and say, well, you can't do that. That's against the Constitution. Doesn't matter. Write it up anyway. Well, maybe they try to pass it. When it gets passed, they'd say, why would those judges? They're ruining our statutes. Well, that's their job.
Yeah,
that's their job.
And I just want to add to what Jim said. I mean, there's a natural conflict between the legislature and judges, right? Because the legislature, they're partisans. Right. They're supposed to only look, the next 2 years, it's their outlook, and the judges defend the Constitution and individual rights. That's a natural conflict. What happened in 2021 was outrageous, completely outrageous. I mean, and we should say it for posterity's sake. During this fight about eliminating the Judicial Nomination Commission, the legislature went to the governor, who oversees the information technology for the whole state, oversees the email servers that judges use. And they took thousands of emails from judges without telling them.
They captured them, yeah.
They hacked them. They took them.
On a Friday afternoon.
Friday afternoon.
Without telling.
When the chief counsel for the agency, who would have said no, had gone home.
Yeah,
They
and
called-
without telling the court administrator that her emails were being raided.
Thousands of emails that have, youth information, highly confidential. So the kind of stuff that should be confidential.
So a real abuse of the subpoena process by the legislature. Legislative subpoenas are supposed to be confined to aid to developing legislation.
Right.
But we all know what's going to happen in Washington with the Republican House Republicans they're talking about investigations. Well, it should be related legitimately to legislation. It shouldn't be like court-like prosecutions, but that's what happened here.
Yeah,
last year.
And the fact that they share an email server, for example, that the governor can just take it shows that we have certain assumptions about the norms of separation of powers that were just totally thrown out the window in 2021. And this resulted in litigation that went all the way to the U.S. Supreme Court. The legislature went kicking and screaming, trying to say what it had done was correct. And I really hope for our state that we can find a way to turn the temperature down in politics, because when people start to throw these norms out the window, start to see judges as only functions of left or right or who's going to benefit, when everything is a zero-sum political game, you start to realize our Constitution, they're words on paper without institutions to defend them. And I see a real directed attack on our institutions. It's starting with the courts. It won't end there. So we got to find a way to turn the temperature down.
Well, one thing about, in this whole series, and we're dealing with the Constitution and the framework of laws that makes our democracy function, and you end up in a situation where, well, we call it rule of law. When something comes out and it becomes a statute, unless it's challenged, it's the law. And if it is challenged and the Supreme Court changes it and says that's the law, and then of course as officers of the court, you as attorneys are officers of the court, you're obligated as our citizens to obey the law that way, that when an order comes from a court, you obey it. I will have to say, in this outrageous period, we had an attorney general who said, I'm not going to obey that court order. If you or I had decided not to obey a court order, we'd be probably in jail for a few days under contempt. So we have to always be watching out for people who think the law applies to everybody but themselves. And the rule of law and the order, the way we do these things is just important. And one reason we talk about the Constitution in this whole series is to help our citizenry to see it, understand what's in this and how does it all work together. And it's fair to say it was outrageous. Let's talk about the privacy and the Armstrong decision and the Graybill decision, things that happened. We have a very strong right of privacy in our Constitution, maybe uniquely strong. Let's talk about what came out of that thing in terms of, say, the Graybill decision. Do you recall that one?
Oh yeah, the rights of individuals to privacy in their home and their sexual relations is very important. And the interesting thing here is with the U.S. Supreme Court deciding the Dobbs case, overruling Roe v. Wade, and Montana has its own constitution, which is stronger on privacy. And the Armstrong case established the right to abortions under the privacy provision. And we, unlike the federal Constitution, have an explicit right of privacy. But the state is now trying to argue, well, we're overruled by the federal law. Our decision was was based on the federal law, which it wasn't. If you have independent state grounds, state constitutional grounds for your decision, then the state constitution should prevail. Now, the U.S. Supreme Court doesn't always abide by that rule, but that's the rule. And so that's going to be probably, that's in litigation now, isn't it, Raph, on appeal?
Yeah. So the Armstrong decision was back in what, 95 or so, or 97, 99, and the Armstrong decision said we looked at our privacy thing, and not related to Roe, not related to the federal decision, but independently said this, our right standing alone provides a right to someone to have the right over reproductive health care choices, and it's standing, and so we are not dependent upon Roe. And I think the interesting thing about Montana and the protection of that right in Montana is that the Supreme Court kind of said, we're throwing it to the states. Well, throw it to us. We've already said what it is. Now, I think the Attorney General and Governor are trying to say, well, it doesn't mean that really. Roe is in the middle of this, but Roe is not in the middle of it, as I understand reading it, that it was totally based upon our Montana Constitution, which is fortuitous, I guess I would say.
Totally is maybe a little overstatement.
Okay.
It was primarily based on the state constitution. So you get this argument, well, was it guided by the federal law? And I was a victim of that years ago on a right to remain silent, where the U.S. Supreme Court kicked the case back to the state and said, did you base your decision, did the Supreme Court base it on the federal Fifth Amendment or on the state? And Justice Morrison held it was based on the federal, guided by the federal Constitution. So I lost that one, even though I thought we had an independent state ground. So it's not as clear black and white.
Okay.
I mean, for practitioners, I would advise in the future, make darn sure that you're just basing it on the state constitution.
Yeah.
That's much different from when I started practicing law, when there was a huge states' rights movement against the integration movement in the South. And so we looked at the federal courts for salvation on individual rights. Now the pendulum has turned, and you look to the state constitution because the feds are sort of bankrupt now. The federal Supreme Court, in my opinion, is now awful.
Yeah, well, they're activists, to say the least.
Yeah. And four of them have this brand, I'm ashamed to say.
You know, I want to do very quickly because we're getting close to having to wrap up. The Graybill decision applied that to sexual relations with consenting adults in their home, and that evolved into a marriage, the Marriage Equality Act, if you will, or decisions. And we were, by doing the Graybill decision, Montana was way ahead of the federal court.
Yes.
Mm-hmm. Yeah, way ahead of the federal court. Well, you know, there's a lot more we could have talked about. We had a list here that was pretty long, but you've both been extraordinarily informative and helpful in this. I think it's important for people to recognize that where the Constitution is in a hierarchy of laws, and we depend upon the legal profession to take care of us when we're just citizens, when our rights are somehow abused in this process. That whether the impact is by a rule and regulation or by a statute, they both have to fit under the Constitution, and there's so much that goes on in this thing. It's extraordinary. We could probably do a whole other session of this. I don't think we have room in the budget for the program for it. But in any case, thank you, both of you, for helping clarify so many things for people who are watching us, and for all of you who are our viewers on Last Best Constitution. We appreciate you being with us. We appreciate your interest in the civics of Montana, and we look forward to seeing you on our next episode.